Welcome to the 504 training. The purpose of this training is to provide you with an overview of legislation and the foundations of Section 504 to increase your understanding of why the district needs to revise procedures. Section 504 of the Rehabilitation Act of 1973 is major federal civil rights legislation that impacts entities that receive federal funding. It was designed to protect persons with disabilities by preventing any form of discrimination based on disability. The Rehabilitation Act and the Americans with Disabilities Act and its Amendments Act are sister statutes. They share common eligibility language and a civil rights approach to disability discrimination and doctrines. Lessons from one law are frequently applied to the other. Students eligible under IDEA have these same civil rights protections. The main emphasis of Section 504 in schools is on non-discrimination and equal educational opportunity for eligible students with disabilities. This is primarily accomplished by providing appropriate accommodations and services to eligible students. Section 504 also requires that eligible students are afforded an equal opportunity to participate in extracurricular and non-academic activities. Because Section 504 is a civil rights law, it provides protections against discrimination in the form of rights to complain and sue in response to discrimination on the basis of disability. Under Section 504, districts and individuals can be sued for monetary damages. A major change in the amendments was to remove the educational need requirement for eligibility. Students do not need to have an educational need to be Section 504 eligible. Eligibility is about reasonable access and non-discrimination. For example, under the old rules, students in advanced programs would not typically qualify because they would not have a perceived learning need. The eligibility definition is much broader now. The Section 504 committee now has to base need on to what extent, if any, the student required accommodations to achieve progress, not on the educational need for accommodations or the end grade result alone. Because eligibility is about reasonable accommodations and non-discrimination, students may have disabilities that in no way affect their ability to learn, yet they may need accommodations of some kind in order to access learning or participate in school-related activities before, during, and after school. While the Amendments Act broadened eligibility, it did not change the three-pronged approach to eligibility. An eligible Section 504 student is still one who has a physical or mental impairment which substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. To determine if a student with a disability is eligible under Section 504, each of the following accommodation areas must be considered relative to the student's disability: instructional and testing accommodations, physical access accommodations to navigate the campus or classroom materials and equipment, behavior accommodations, or medical interventions and health services. A student who is determined to have a disability is not automatically eligible under Section 504. In addition, just because a student is considered for Section 504 protection does not always mean that the student is eligible. The disability must substantially limit the student, the school data must support the need in the area of the disability, and school staff must use all data and professional judgment to determine eligibility. Through the Amendments Act, Congress wanted the law to be interpreted to maximize eligibility as reflected in the changes made to the meanings of the following provisions. The standard used to determine if an impairment results in a substantial limitation is average performance in the general population, not just within a classroom, a school, or the district. The standard is not based on a student's optimal performance level. OCR has interpreted substantial limitation to mean an important and material limitation. It does not mean significantly or severely restricted. The major life activities categories have been expanded. Before the Amendments Act, 9 major life activities were outlined, including hearing, speaking, learning, and working. After the Amendments Act, 9 more major life activities were added, including reading, concentrating, thinking, and communicating. If a student is substantially limited in part of any of these major life activities and the student has a disability, the student is eligible under Section 504. Congress also provided that a major life activity also includes the operation of a major bodily function, including but not limited to the 11 functions listed below. Prior to the amendments, episodic impairments were typically not covered under 504. Now, students commonly qualify under Section 504 if their condition, while not constant, episodically rises to the level of substantial limitation of a major life activity. The Amendments Act also requires schools to consider impairments that are in remission. An impairment in remission was once present but hasn't returned. It is a disability under 504 if it would substantially limit a major life activity when active.
When should a student in either of these cases be referred? A student with an episodic impairment should be referred for Section 504 consideration. Typically, there is no duty to refer simply because a student has a condition in remission. The referral to the 504 committee should occur when the school suspects the impairment in remission is beginning to substantially limit the student in relation to instruction, physical access, medical, health, or behavioral needs.
Mitigating measures are supports provided by parents, students, or staff members to assist a student in compensating for the effects of his disability. 504 committees cannot consider these helpful effects when determining eligibility. A student is considered disabled under Section 504 if he has an impairment that would substantially limit him in a major life activity if he was not taking advantage of mitigating measures. The 504 committee cannot consider the beneficial effects of medication when determining whether the student is eligible under 504 as having a substantially limiting impairment. The medication can later be considered as an accommodation when developing the 504 plan. Glasses and contacts are exceptions to this rule and do not need to be listed as accommodations in the student's 504 plan. If a student's only disability is a vision impairment that is corrected with glasses or contact lenses, the student is not 504 eligible.
Our focus as a 504 committee is upon equal access and provision of support as if the mitigating measures are not present.
There are two types of eligible students under 504. One is an eligible student who requires no services, and the other is an eligible student who does require services.
Both types of eligible students receive annual meetings, 3-year reevaluation, and non-discrimination protections such as manifestation determination review and procedural safeguards.
Students who qualify under dyslexia criteria will always have to be considered for 504. A student with a dyslexia diagnosis who receives dyslexia or reading intervention through the Instructional Intervention Teacher at elementary or a specialized reading course at secondary will require a Section 504 plan. Teachers must collect data on effectiveness of accommodations to determine whether the routine and consistent use of each accommodation is helping the student make progress. A student with an ADHD impairment will now be considered for Section 504 under the major life activity of concentrating or thinking. Most students with ADHD will qualify with the new major life activities that have been added. Whether the student takes medicine or if medicine is administered on campus is no longer a consideration. The 504 committee must look at the student without the helpful effects of the medicine in place.
Teachers must collect data on effectiveness of accommodations to determine whether the routine and consistent use of each accommodation is helping the student to make progress. Asthma is a common example of an episodic impairment. When a student has a medical diagnosis of asthma and a written plan in the school clinic that includes things such as routine medication, rescue inhaler provisions, an emergency plan, etc., then the student will qualify under Section 504. A student with asthma will continue to qualify for accommodations until a physician reports that the condition no longer exists. OCR cites diabetes and epilepsy as two impairments that should result in a finding of disability in virtually every case. A school district's evaluation should not need or require extensive documentation or analysis to determine that a student with diabetes or epilepsy has a disability under Section 504. If a student requires accommodations for equal access and participation, those are noted in his 504 plan. If accommodations are not required for a student with a diagnosis of diabetes or epilepsy, then the student is monitored only.
Now let's look at what the school's responsibility is in implementing and enforcing Section 504 on campus. The school has 4 main responsibilities: child find, periodic reevaluations, accommodations, and manifestation determination. Child find is the school's duty to evaluate under Section 504 and is triggered by the school's suspicion that a student is disabled and in need of services. Some possible triggers for the school to evaluate are listed below. Additional reasons a campus might decide to refer a student for 504 evaluation are listed below. Evaluation under 504 is completed by the Section 504 Committee. The committee consists of a campus administrator, the 504 coordinator, and persons knowledgeable about the student, the impairment, and the available accommodations, services, and programs. These committee members include a parent, classroom teacher, a reading specialist when appropriate, and a nurse when appropriate.
The most important thing to remember when making decisions about referral and eligibility under Section 504 is that the determination is made on a case-by-case basis. If a parent requests 504 for a condition that is unfamiliar to campus staff, resources include the school nurse, the National Institutes for Health, and the 504 program coordinator. Parents have the following rights under Section 504. Written notice of parent and student rights, written notice of all district decisions concerning 504 for their student, the right to review their students' records, the right to appeal the decisions of the 504 committee, the right to an impartial hearing with or without legal counsel, and the right to file a complaint with the Office for Civil Rights. OCR has also recognized 2 significant parent rights in regards to consent. The first is a right to consent to initial provision of 504 services. The second is a right to revoke consent for continued 504 services. Keep in mind that when a parent revokes consent for 504 services, this does not revoke the student's eligibility as a student with a disability. In this case, the student must remain under monitor-only status.
The second school responsibility under Section 504 is periodic reevaluation. Reevaluation can occur in the form of a 504 committee meeting at least every 3 years. In the case of a student needing a manifestation determination review, the MDR meeting can be documented as a reevaluation and an MDR and meet the reevaluation requirement, even if the meeting is held before the 3-year period. Remember, reevaluations should occur prior to any significant change of placement. Expulsion or suspension for 10 or more cumulative days is a change of placement, and a student will need a reevaluation.
Instructional accommodations are routinely and consistently used, must be written into the 504 plan, are intended to level the playing field and to provide access. They are not intended to provide an unfair advantage or to maximize a student's potential. Instructional accommodations should be reasonable and aligned with the area of the student's impairment. When written into the plan, the teacher must provide the accommodation daily and as specified in the plan. Testing accommodations are those that are needed on a routine and consistent basis and must be documented in the 504 plan. When making decisions about state assessment accommodations, the 504 committee must follow the TEA criteria for both the type of accommodation and the student criteria for eligibility. Teacher data must indicate that the student uses and requires the accommodation on assessments. Data must support that each accommodation results in improvement when used by the student as compared to when it is not used.
Manifestation determination is a 504 protection afforded to any student who qualifies, regardless of the need for services. Expulsion or suspension for 10 or more cumulative days is a change of placement, and the student will need a 504 reevaluation through a manifestation determination 504 meeting. No clear ruling has been received regarding when a manifestation is not needed. Until such time, a manifestation determination review should be held on all 504 students who have discipline hearings. Students with diagnosed disabilities who receive services through Section 504 will virtually always qualify unless the condition changes. Parents or adult students are encouraged to provide a new doctor report every year, but failure to do so cannot result in removal from Section 504. By the new standards, the school needs only to have knowledge of the condition to proceed for evaluation or continuation in Section 504. Here are some common questions and answers about Section 504. Can a medical diagnosis suffice as an evaluation for the purposes of providing Section 504 services? No. A physician's medical diagnosis must be considered among other sources in evaluating a student, but cannot be the sole source of evaluation data. Campus data must also be considered and must indicate that the student is substantially limited in school and/or extracurricular settings and activities. How should our Section 504 committee deal with a temporary impairment? Keep in mind that an inconveniencing temporary injury or illness does not necessarily mean the student has a disability under Section 504. OCR consistently has stated that temporary, non-chronic impairments that heal normally within a few months, usually less than 6 months, are not commonly regarded as disabilities under Section 504. The 504 committee needs to consider the degree of limitation and err on the side of caution when making decisions about temporary impairments. Does a student have to fail in order to be 504 eligible? No. The committee needs to consider the major life activity that is impacted and whether or not the student has needed accommodations and/or other services to earn the grade. For example, a student with dyslexia might not be failing reading, but does struggle with reading and may only be passing because of the interventions in place. Can a student ever be simultaneously served through both a Section 504 plan and an IEP? No. All students who are eligible under IDEA are also eligible under Section 504. This means that if a student is eligible for special education services, his plan is documented through an IEP. If a student has had a 504 plan and then becomes eligible for special education, then all Section 504 accommodations need to be provided to the ARD committee and considered for inclusion into the student's IEP. Likewise, make sure that when a student no longer qualifies for special education, that a Section 504 committee meets to consider placement in Section 504. Keep in mind that if a parent or adult student denies special education, they do not get a Section 504 plan as a default, but they are considered for Section 504 eligibility. Do the Section 504 non-discrimination protections extend beyond the walls of the classroom? Yes, students with disabilities must be provided an equal opportunity to participate in extracurricular and non-academic activities. Students need to be otherwise qualified and accommodations must be reasonable. OCR's definition of an unreasonable accommodation is a fundamental alteration in the nature of a program that in turn brings undue financial and administrative burdens. More guidance about participation in extracurriculars and non-academic activities is provided on the 504 website. Can a 504 student receive transportation? Yes, if the need for transportation is related to the student's disability. The 504 campus coordinator must consult with the district 504 program coordinator prior to offering transportation. Parents should be informed that disability-related transportation is provided on buses that are designed for students with special needs. What is the parent's role on the Section 504 team? Section 504 does not require parents to be in attendance at meetings. However, OCR requires districts to provide parents with meaningful input into the plan. Best practice is to make parents a member of the 504 team. In NEISD, parents are invited to meetings, provided parent input forms, and encouraged to participate. District resources available to support Section 504 include the 504 Program Coordinator and information housed on the 504 intranet website.